Please, Your Lordship. My Lord, I beg to make a mention of item number 5 hearing list.
Item number?
Number 5, Your Lordship. I humbly request after 2 weeks, Your Lordship.
You are for
the appellants, Your Lordship.
Respondent 1 and 2, my Lord.
you are for petitioner, appellant.
For the appellant, Your Lordship. No objection, Your Lordship.
Mr. Letter Counsel for the respondent number
1 and 2.
1 and 2
1 and 2, Lordship.
has sought for adjournment on grounds of personal difficulty. The same not being objected to by the Letter Counsel, Mr. Letter Counsel of the appellant, that is adjourned as prayed for. List this matter to 2 weeks.
Oblige, Your Lordship.
Please, Lordship. I beg to mention item number 6. Lordship, in this matter, we are required to prepare a paper book, informal paper book. So I'm praying for another 1 week's time now.
On payment with appellant, list this matter to 1 week.
Oblige, Lordship.
Daily list item number 1.
Lordship, I am appearing on behalf of Mr. B.K. Singh, who is right now on leave, Lordship. My Lord, it seems that fresh step has not been taken against respondent number 2. We beg for sincere apology, Lordship. We need 3 days time to take fresh step.
Your Lordship, in this matter, I pray since steps have been taken, Your Lordship. Last date, Your Lordship, they were supposed to take steps, Your Lordship, in this matter. This matter will be dismissed, Your Lordship, this appeal.
You want to take first steps, so let them.
This is the second time, Your Lordship.
But at least we have to give them full opportunity. If at the end of the day they don't appear, then matter, we'll proceed accordingly.
Yes,
Miss, yes, Miss, what's your name?
Lordship, S. Sharma appearing on behalf of Mr. B.K. Singh.
Yes, Miss S. Sharma, Letter Counsel for the petitioner, for the appellant, has submitted that the steps for service of notice upon the respondent number 2 has not yet been completed and has sought for some time for the same to be has sought for some time for such steps to be taken and a report to be filed before this court. On premier, this seems allowed. At premier, this seems allowed. This is matter after 2 weeks.
Oblige.
Item number 2.
Oblige, Lordship.
Yes.
May it please your Lordship. Your Lordship, in this matter, the Advocate General is supposed to appear online, Your Lordship, but I think there's some technical issue, Your Lordship.
End of the board.
Oblige, Lordship.
We'll wait for a while.
Item number 3.
Good morning, Your Lordship. Lordship, I filed a criminal misapplication which is before your good self, through which I'm seeking extension of interim bail granted to the accused person, which was granted by order dated 26th of September 2024 in bail application number 32 of 2024. I'll take you to page 20. So page 20 is basically the 4th page of the previous order passed by your Honorable Self. I'll take you to paragraph 18, paragraph 11, Your Lordship, page 20.
Yes.
This court, having heard the argument advanced by the learned counsel for the rival parties, is well aware that extension of the interim bail has been granted from time to time to allow the accused, stroke son of the petitioner, to get proper medical treatment for his complaints. However, even today the situation has not improved in as much as medical reports as has been produced before this court would show that the accused patient still requires proper medical attention. With deference to the medical advice as regards the treatment of the accused patient, coupled with the fact that the required disbursement of funds to enable the petitioner and his family members to admit the patient at CMC Vellore has not yet materialized, it would be but proper to give some more time to the petitioner to take necessary steps in this regard. Without going into the merits at this point of time, the prayer of the petitioner is allowed. However, the prayer for grant of absolute bail will not be considered as yet, except to say that a case for extension of interim bail granted earlier has been made out. According to the interim bail granted by this court, while order dated 26th of September 2024 in bail application number 32 of 2024 is hereby extended for a period of 90 days with effect from today, with effect from 26th of March, February 2025, which expires today, Your Lordship. Now, I've come before your good self again, Your Lordship, seeking for extension. Now, the grounds for which I seek extension are because, Your Lordship, after the passing of the last order, which is on the 26th of February 2024, the funds finally arrived in the account of the accused person's mother on the 28th of March. I'll take you to annexures 2 and 3, Your Lordship, which are at page 22 and 23 of the petition. So page 22 is a letter addressed to the mother of the petitioner. I'll take you to paragraph 4, which says the medical advance of rupees 1,50,000 only, which is 3/4 of the recommended amounts, is sanctioned. So the recommended amount, Your Lordship, was 2 lakhs. 1,50,000 was sanctioned, which finally arrived in the account of the petitioner's, the accused person's mother on the 28th. Annexure 3, Your Lordship, which is at page 23. As you can see, Your Lordship, your account had a NEFT incoming transaction of rupees 1,50,000 on the 28th of March. So the amount which would have enabled the accused and his mother to travel to Vellore for the treatment arrived on 28th of March. Unfortunately, what happened, Your Lordship, after that, the escort or the mother of the accused person who would have escorted him to Vellore fell severely ill. So I've annexed her papers at annexure 4. She was admitted in Negrams for a period of 3 days. Annexure 4, Your Lordship. The name is Esther CM. So she was the person who was supposed to take the petitioner, the accused person, to Vellore. As you can see, Your Lordship, on the right hand column, the date of admission is given, which is the 1st of April. Day after the date of discharge is the 4th of April 2025. She was diagnosed with quite a few ailments, including type 2 diabetes, hypertension, and ulcer as well. Thereafter, Your Lordship, on the 8th of April 2025, a medical certificate was given to her whereby she was advised 1 month of bed rest. That is apparent from a reading of annexure 5, which is at page 25. I, Dr. Such and Such, after careful examination of the case, certify that Miss Esther CM, whose signature is given below, is suffering from such and such diseases, and a period of absence of duty of 1 month is recommended. And Your Lordship, that is why we were a little delayed in reaching Vellore. After her health was a little better and after replenishing her health, she booked tickets for herself and for the accused person to go and visit Vellore on the 20th of May 2025. Thereafter, both these individuals visited Vellore. The ticket also have annexed to Your Lordship as annexures 6 and 7, which are at page 26 and 27. So these, at page 26, Your Lordship will find the ticket of the accused person whose interim bail was extended by the last order, Daniel CM. And at page 27 is the ticket of the flight ticket of the mother. So on the 20th, Your Lordship, the flight tickets were booked. They arrive at Vellore on the 20th. They immediately go to the CMC hospital. And the admission slip is at page 28, Your Lordship, annexure 8. So upon arriving at Vellore, they immediately rush to CMC Vellore. And then the accused is advised to come back to the concerned department on the 22nd, the day on which I filed the application, 22nd of May 2025. So he visited the doctor. The doctor has asked him to undergo a few tests. And today is his second appointment with the doctor, Your Lordship. So based on the test, he would either be recommended for an operation or he would be given a few medicines and probably be asked to come back. We do not know as on date. So as on date as well, Your Lordship, he is in Vellore.
To cut the story short,
Yes, Your Lordship.
he is still undergoing treatment.
He is still is. Lordship, just a few points of emphasis. I'm so sorry. The subsequent annexures which I've annexed are also annexures which show that he suffers from mental disorder.
That is a different thing.
That is
We will not go into that.
right.
Yes, Mr. Khan.
Lordship, nothing much to say. I think he's made out a case.
What Mr. S. Yadav, learned counsel for the petitioner, who has made a prayer for grant of further extension,
Also sought regularization if because
the interim bail granted by this court to enable the son of the accused son of the petitioner, or he is a petitioner himself.
the petitioner this time is the aunt of the accused, Your Lordship, because the mother is with the son at Vellore.
Move on to the last slide. By the order dated
26th of September 2024.
which period expires today. The petition has been filed by the aunt of the accused person in question. It is the submission of the learned counsel that because of the formalities of receipt of the sanction for the cost of treatment of the accused by the mother of the accused from the government, and the subsequent illness of the mother of the said accused, who is supposed to escort him for his treatment at CMC Vellore. The accused person was finally able to proceed to the said hospital and was admitted on
Lordship,
when was he admitted?
he was not admitted, sir. He visited a doctor on the 20th. He was asked.
And had gone for his
Consultation.
medical consultation on 22/5/2025. He was advised to wait for the report, which in all probability may be for recommendation of his further treatment at the said hospital. Since he is still undergoing treatment, the learned counsel has made a prayer that the interim bail granted may be further extended. To support his case, the learned counsel has annexed the appointment slip at the CMC Vellore concerning the said accused person. Annex at Annexure 8, page 22 of this petition. Next, Mr. K. Khan and PP has no objection to the prayer made by the learned counsel for the petitioner. on the ground that the same appears to be genuine. Next, therefore, on consideration of the submission made and on perusal of the petition, including the annexures, relevant annexures, this court is convinced that the petitioner, that the accused person, that the interim bail granted to the accused person be extended. Accordingly, the interim bail granted by this court's order dated. When was the first bail?
26th of September 2024.
26 September.
September.
By this court's order dated 26/9/2024 is hereby extended for another 90 days period.
Obliged.
Counting from today, at the end of the set period, the accused is directed to report himself before the prisons authority at the district prison and correctional home, Tribhuvan district. Tribhuvan district. Petition disposed of.
Value. Good day, Lord.
Item number 4.
May it please your Lordship. Lordship, we had received a copy of Miss Case number 81 of 2025 on the 14th. Lordship, may allow us to file our objection on this Miss
It's the
Case,
same
Lordship.
Miss Case, Your Lordship. Only they were not aired as a party. Now they have aired as a respondent number 6. Only that part changed. The other things, cause title is remaining same. Only both sides were heard, Your Lordship. They have also given their decisions.
Okay, the observation last time was
Yes,
your
yes, as
mistake.
per Your Lordship last order.
Okay, since they've been made a party, then they have to be heard.
Lordship, hearing is to be done.
But I believe Mr. Paul was heard in this matter.
It was heard actually. The affidavit replied to be allowed to be withdrawn by the same.
Exactly.
Only,
On that,
only
that is your petition. That is your Miss Case 75, is it?
Lordship, hearing is to be done on this Miss Case too.
Just delaying the matter. Miss Letter Counsel for the petitioner has submitted that the petitioner has received copy of the said application filed by your
Miss
respondent.
Case 81.
No, in the main case, your
Respondent number 6. We
filed
have
by the
had
respondent number 6 in the main case. The said petition being numbered as Miss Case number
81.
81.
81 of 2025. 24, 25.
25, Lordship.
May now proceed to allow the petitioner who has been arrayed as respondent number 6 in the said application to be heard.
Apart from that, may I pray Your Lordship, the whole case become infructuous. That also may be heard at the same time, Your Lordship, because everything has become infructuous.
We'll see.
Of course,
You would say that, but we'll see what is their stand.
no. Last
They are
time
the
also they
petitioner.
said about the land custom something to be there, but land custom they are the tenant, CM's tenant. We have all the
So
documents.
then, you see, in that case, then the merits has to be, heard. So, otherwise, what we could do is, if you choose not to pursue with this application, then the the whole case is maybe heard.
It can be
And
hard.
merits will
That's what
be-
I'm just making a submission, Your Lordship.
that would be proper.
I don't know, but
Otherwise,
Mr. Paul is
going piecemeal like this. may not-
piecemeal. Therefore, Mr. Paul is not here, so that can be put in the order that I'm saying that you become infractions. That matter also can be heard together.
That is your stand, but we are yet to hear. The court is yet to hear what they have to say. Then we'll do one thing. We'll discuss this matter tomorrow. Where's Mr. Paul?
He's on legs, Your Lordship.
Day after tomorrow, or maybe next day, Thursday, I think.
Only to be confirmed of this point as to whether they are agreeable to for the whole petition to be heard on merits, ignoring whatever this case has been filed.
No, even Mr. Temis from district also said become infractions. This matter.
That's
So,
a different thing.
anyway, I leave out to your lordship. So can it be day after tomorrow? So, or if not day after tomorrow,
But,
on 29, if lordship.
29 is Sunday.
where Mr. Paul is? Yes, Miss.
Lordship.
Mr. Paul is on legs.
Lordship. In courtroom number 2, Your Lordship.
Room 2.
Because tomorrow I'll be
Where
out
he
of
is
station.
on legs, practically making submission, or he's sitting
Your
there in
Lordship
the
is
court.
making submissions. Item number 4, Your Lordship.
तो कोई का युला already belum? Should we take it up at the end of the boat?
Day after?
Should we take it up at the end of the boat?
Lordship may
If
have
the parties are agreeable
Yes.
to that, then the court will post this matter to another date for final hearing. Otherwise, then we are stuck at the point where we have to hear that the court has to hear that petition.
But in fact, I talked to Mr. Paul also that it become infractions. He is telling about the land custom. So for that, I have prepared also. Of course, of the court, I just told him.
Lordship may have it next week.
We'll take it up. Mr. Manta, you said day after tomorrow.
Day after tomorrow, I'm okay.
We'll post this matter day after tomorrow.
Day after tomorrow. Because tomorrow I'm out of station. I'm sorry.
I'll not pass any effect for that.
Yes.
On premier by the council of the parties. Yes, this matter day after tomorrow. Let this matter on. No, 28. So 28.
Obliged, Lordship.
Much obliged.
Second call, item number 2.
Yes, Mr. Bora.
May I please, Your Lordship. Your Lordship, the AJ is currently not available, Your Lordship. However, Your Lordship, as per the last order, we were supposed to file an affidavit, Your Lordship. We require some more time, Your Lordship.
On the last date, they had already filed it. On the last date, they had already filed.
This is the
rejoinder date file.
reply today. They have filed.
We have not filed, Your Lordship.
They have received a copy of it. Rejoinder, they have filed it. You check it.
I was informed, Your Lordship, to pray for some time, Your Lordship.
Today's date was taken as per your convenience.
Just let us check.
Yes. Actually, the last date was given on 28 and 22nd, either after 2. But again, they took time for today.
No, they have not filed, Mr. Bora. It's not on record. You have see what happened is you have filed the affidavit.
Lordship.
They are supposed to file a rejoinder to that.
Yes, Lordship. A copy. This is the copy, Lordship.
But we did not file, Your Lordship. That is what I was informed, Your Lordship, by
You
the
have
assisting
received copy
counsel.
and
That's what I am surprised. They've served me this copy and they will be filing on the day itself. I don't know what type of practice, my lord. I'm what to say. On the same day they have given me, then they are about to go to file it. One decision
Your
just
Lordship,
taken.
maybe there were some corrections that needed to be done.
No, Lordship. I waited for a long while, and after that, they've
We
given me a
must have
copy.
served copy to him, but maybe there was some correction. That is why we were unable to file.
Maybe it doesn't work out. No?
I think that should not be the practice. See, until and unless
Yes,
you
Your
see
Lordship.
everything is in, is
Yes, Your
complete.
Lordship. My apologies, Your Lordship.
Thereafter, you
Yes, Your Lordship.
you
Several times,
give him a copy.
Yes, Your Lordship.
several times also they have been following such kind of practices, my lord. I waited for a while, then after that they have given me a copy. They went to the filing section, and even, my lord, the date was given on 28th or 22nd as per their convenience. So later they have taken it on 26th.
In fact, I'm not so sure, but previously there is this practice of whenever an affidavit is filed, an advance copy given to the other side, a copy of that the receipt is annexed with the and then file.
Yes, lordship. I received it
Is
also.
that so, Mr. Monta?
I received
Yes,
it
Your
also.
Lordship. We have
You
to
are
get submissions.
more experienced in this matter. Do we do that earlier?
Yes, Your Lordship.
You see, whenever an affidavit is
Before
filed,
filing, they serve the copy to the other side.
and a receipt of that
Yes.
is attached to the to the copy that is to be filed in court, and then filed.
I had received it, lordship.
They have to sign the receipt.
No, that is true. Receiving an advance copy is not a problem. You could have received, but the fact now she's saying that after giving you the copy, they've checked some mistakes, and then they have yet to file it.
Previously also they had given the same reason in taking time.
But I think what rules we are following.
I'm surprised. Same technique they had applied previously also. Last month.
I'm just more concerned about only the acknowledgement of receipt, whether it's to be attached with the main petition and with the concerned petition and filed in court, or it's done just like that. Of course, main petition means once you file that notice, receipt notice has to be there, affidavit of service to be filed. That's a different thing. Only in these internal petitions to be filed.
And there's, my lord, the issue is very simple, lordship. Nothing to find any kind of rejoinder in regard to it regarding maintainability, my lord. Simply it can be heard itself.
Up to them.
For you, everything is simple.
No, it's fine. No, definitely, it's for your lordship too. Regarding maintainability, your lordship.
I'm not so well versed or well advanced as you are.
No,
So,
not at all, not at all. From any angles,
please
not at all.
give me some time to understand the situation.
Lordship.
Good. This cannot be easy. You have filed. Thank you, Mr. Monta. Thank you.
No, please.
Miss, I am well that the appearing for the petitioner has submitted that the reply to the affidavit filed by the respondent has not yet been filed. Are you filing it today?
Yes, not today, Your Lordship. Just a week's time, Your Lordship. We require some clarifications, Your Lordship, from the department.
Why have you given an advance copy then?
Yes, Your Lordship. That is what I was informed, Your Lordship. My
Surprise,
apologies.
Lordship.
We'll give him a
This is a
fresh
copy,
copy,
Lordship.
Your Lordship. We'll give him another copy.
They're simply taking an opportunity to take time. That's all, nothing else.
We'll give him a
What
fresh
to?
copy, Your
It
Lordship.
doesn't matter. Eventually, the matter will be decided.
Simply should be decided on hearing itself, nothing to file regarding maintainability.
I have maintained, you see, in the earlier, I think, when the matter was taken up on the last occasion, that as far as, in revision, it is never, it's never heard of that you have to file an affidavit in opposition, then reply to be filed or rejoinder to be filed. That's not done.
Basically, my lord, since it's a special statute, my lord.
It's a matter of records.
Lordship.
But you have insisted to file the affidavit.
No, basically, my lord, this is a special statute in which, my lord, Article 227 doesn't apply from any angles, my lord. There are several judgments in regard to
That's a
it also,
different
lordship.
thing.
So on that basis, it can be
You press that issue in hearing. In the hearing, you can do that, but not. But now, you see, on your insistence, the court has granted you that opportunity. Now when it comes to their reply, you have to wait. If you had just pressed for hearing of the petition at the first instance, it would have.
No, yes.
And has therefore prayed for some time for the same referral. Mr. Ibora appears for the respondent. On pre-meet, file it by Friday.
1 week, Your Lordship.
Friday is enough, Your Lordship.
1 week, Your
Same,
Lordship.
same substance, same copy,
week's time, Your
only to be filed. Friday is fine. Friday is fine.
Fine. Last line. On pre-meet, the same is allowed. Let the said reply be filed on the next date fix. As prayed for, this is matter on 2nd June. That's exactly 1 week and no more time.
Much obliged, Your Lordship.
Few minutes earlier, he has stated the AG will appear, he will make a submission. Now she is making this kind of submission.
If he makes that kind of submission, which they are competent to make, then I don't understand how the state will function.
Lordship.
Much obliged, Lordship.